All right. Good afternoon, everyone. Happy Friday. My name is Greta Schultz. I am the chair of the Intellectual Property, Internet, and New Media section for the Beverly Hills Bar Association. I am also a partner at Heppenstall Schultz. We are a civil litigation firm primarily dealing with matters of intellectual property and business litigation. I will also be your moderator today. We are going to, as the title suggests, talk to you about how to handle intellectual property bullies. And the way we're going to present this today is, given the sort of vastness of the topic, we're going to give everyone first a general overview of what an intellectual property bully is, sort of differentiating between what a patent troll is and what a trademark bully is. And then we're going to do a little bit of role play, giving you guys a real world scenario where we can provide information regarding preventative measures that you can take if you have clients, say, starting a new business or with a new invention. And then we hope to provide you with some legal strategies and tips that you can use if you're forced to litigate against these intellectual property bullies. So first, I want to go ahead and introduce our speakers today. We have Mark Plager. Mark Plager is a partner at Plager Schack. Mark has over 32 years of experience preparing and prosecuting patent and trademark applications. He's also litigated intellectual property and complex business matters for both corporate and individual clients, and he's taken numerous cases to verdict and through the appeals process. Mark also has a unique insight into the insurance world and types of insurance that, believe it or not, are available for business and IP matters. We also have Michael O'Brien. He is the founder of O'Brien Patents. Michael, he has prepared and prosecuted hundreds of patent applications and also litigated matters relative to patent and trademarks for individual investors, small businesses, and entrepreneurs throughout the country. Additionally, I will say, Michael has a unique insight into international regulations and registrations relative to IP matters and has become quite the resource for my own law firm as he served of counsel for us on numerous cases. So I'm going to just go ahead and out the gate, like I said, give you guys an overview. I'm going to go ahead and start with Mark. Mark, if you wouldn't mind telling us, how would you describe a trademark bully?
Well, a trademark bully, unlike a patent troll, actually has intellectual property rights in a brand that they're marketing and selling. So from past history, I've had to deal with the NFL, I've had to deal with Pepsi when dealing with my clients that were smaller in unrelated industries, but they wanted to keep clear their brands from any potential of likelihood of confusion to the point of, I would consider almost absurdity with respect to the differentiation. So in one case, one of my clients was coming out with a vending machine for making frozen drinks called Sipsy, and because it sounded too close to Pepsi, Pepsi objected to it. In another case, I had a karate company that was coming out with protective gear called Bengal Series, and the NFL took exception to the fact that we were using Bengals in a sports-related area, all of which we've resolved in different ways.
Got it. Okay, and then Michael, to you, I mean, how would you define a patent troll?
I would say that a patent troll is one who has patent rights, but is not currently selling goods that use the patented technology. The most common type of patent troll that we think of is your company that's a non-practicing entity. It's a company that simply owns patent rights, whether they be exclusively licensed or owned outright, and that company seeking to enforce those rights. Other kinds of non-practicing entities that you may not think of as patent trolls, but would meet the definition are public universities. The two biggest ones are the University of California and the State University of New York system. So those also would fall into this category. In both cases, patent trolls are either trying to extract a large number of small dollar settlements from a huge number of people that might be using some standard essential technology or something of that nature. And there's another business model that deals with going after a fewer well-heeled companies for substantial sums. Those tend to make it into the news a little bit more often.
Nice. Thank you. So again, that's sort of the general overview, but the way we want to present the rest of this is to use an attorney-client scenario where strategies and principles that we want to discuss are going to be put into action, and the client being played by yours truly. So I'm going to go ahead and Mike and Mark, I come into your office. I want to start a business. I have this idea. It's a great invention personally. I came up with it on my own, and it is a skincare machine. It's going to be used for facials. I want to put it in med spas, and I have this whole idea about electronic port, and I'm going to have these hoses, and we're going to have like fluid, and we're going to remove skin, and it's just this whole idea. And frankly, I need somebody to direct me. I need some legal guidance, and I don't even know where to start.
Well, there are a couple places that you can start with. Is first that you can undertake patent searches and obtain freedom to operate opinions. And the patent searches can be done one of a couple ways. Is that you can either hire a firm to do the search for yourself, or if you're inclined, there are what's known as the patent depository libraries, where you can make an appointment, go to the library, and schedule an appointment with the librarian there to assist you with the search. And the closest one to Los Angeles is the Los Angeles Public Library. Alternatively, there's one in San Diego at the San Diego Public Library, and there's also one available at UC Riverside, all of which are publicly available. And if you make an appointment, you can sit down with the librarian there, and they will teach you how to conduct your search. In addition to doing the patent search, either doing it with a firm or doing it yourself, you have to make a determination as to the scope of your search. Is it going to be for international patents, as well as what's been filed domestically here in the United States? Once you have the clearances and you see that you're free to operate and that nobody else has filed for a similar patent, you can then make the decision to proceed forward with your own patent that you can file domestically in the United States, and you can file internationally through either direct filing in the individual countries or through the treaty known as the Patent Cooperation Treaty, which gives you an extension of time. But ultimately, even if you go through the Patent Cooperation Treaty, you will need to file in the individual countries, which can get expensive. Just by round numbers, as I can tell you, generally the filing fee just for the EU is close to $10,000. And that doesn't include annual maintenance fees that must be paid each year after the application is filed. With respect to branding, again, the first step would be to get clearance that your brand is clear, nobody else is using something likely to cause confusion that predates you, because in patent law, your rights are created upon first use, not first to register. So again, you have the option of either using a search firm, or you can begin at least doing the search yourself. Is that the United States Patent and Trademark Office has a search tool available on its website where you can do your own rudimentary searches. In addition to that, I like to tell other clients, including you, that you can also just do a Google search. Just see if it comes up. And if somebody is using it in an allied field or the identical field, you will need to stay away from it. If you believe you've completed your search and you think you're free, then I would always say, let's do the comprehensive search using a vendor. And when I say comprehensive search, it takes into account not only the federal registry, which is at the U.S. Patent and Trademark Office, but it will also search all 50 registries of the 50 states. It'll search the corporate registries of all 50 states. It will do an internet search as well as just a common search to determine what is out there and how it's being used. If after you've done all your searches, you're clear, then you can proceed to filing your trademark registration in the United States. And if you believe you're going to be outside the borders of the United States, you can begin filing your trademark registrations in those countries. In addition to patent and trademark rights, is if you're dealing with information that is proprietary, that is information that you can't get a patent for, it's not something that you wish to have a trademark for, and understanding that if you file a copyright application, you're now publicly disclosing it, which would defeat the value of it, that you would need to implement trade secret procedures, protocols. And some of these procedures will be blocking the information in computers, limiting access to only those personnel that need it, having implementation of hardware and software such as firewalls and other hardware that's available to you. In addition, is you're going to have your employees and independent contractors subject to agreements with confidentiality so that they can't go out and disclose it. And if they do attempt to disclose it, they're in violation of the contract, and you have recourse against these employees or vendors that you're dealing with. In addition to that, there's also, you're going to have to protect yourself against patent trolls and the trademark bullies. And the only way that, besides undertaking the searches, you should look at insurance as a resource to you. And
Oh, wow. Okay. There's insurance for that?
there are various carriers that are available. So let me show you some of the carriers that are available and what your options are. So there are two forms of insurance that are available to you. So as if you're trying to protect yourself against being sued and being able to fund that, you look at defense policy. So there is initially what's known as the standard ISO CG policy, which stands for Insurance Services Organization, Comprehensive General Liability Policy. And an example of that is the Hartford, which is a subscriber to the ISO, which is a form. It's a standard form that's used in the industry. If you don't like the ISO forms, you can also go to other carriers that are available. Chubb Insurance has its own separate policy that's not the ISO standard, which is known as the Premier Tech policy. In addition, Lloyd's of London has a policy, and there's also a carrier known as Ambridge Insurance Solutions, which also goes by Ambridge Hartford. Tokyo Marine has a policy too, as well as Aegis Insurance Market. But as opposed to trying to do this yourself and trying to identify policies, you're best off going to insurance brokers who know the industry. You can talk to them about the risks you want to have covered. And such brokers are Intellectual Property and Insurance Services Corporation, better known as IPISC. They're a broker, and generally their policies are written in association with Lloyd's of London. In addition to IPISC, there's Marsh, which was previously known as Marsh & McLennan, and they have policies that are available, and some of the policies that they have available are through Ambridge Insurance Solutions. There's also Aon, which is an insurance broker, which deals with the entire insurance industry. But the critical thing when you're dealing with an insurance broker is you need to define to them what risks are you trying to protect, what industry are you in, and so that they can go shop the market for you and tell you what's available. The other critical thing is when you make your request to your insurance broker, you should do it in writing, Because if for some reason they fail to get you that coverage that you requested, then you have recourse against the broker for not doing what you asked. Any questions, Greta?
No, I mean, obviously I want to go ahead and do the searches. I'm definitely going to get the insurance. And yeah, I mean, is there anything else I should know?
Yes, there, in addition to the defensive policies, you have what's known as abatement policies. That when we talked about going to register your intellectual property, you want to be able to enforce your intellectual property, whether it's trademarks or patents. And currently is the only available abatement policy that I'm aware of is available through Intellectual Property Insurance Services Corporation. You have to understand that the application process is quite onerous through them, is that you will be expending a lot of money with opinions to submit as part of your application to establish the strength of the intellectual property you wish to protect for purposes of enforcement.
Okay. All right, well, I'm going to go ahead. I'm going to do all that you suggested. And now sort of end scene and just sort of talking to the audience out there. Look, we all know that no matter what we do sometimes, and especially dealing with these intellectual property bullies, just because we do everything right, we do all the searches, we clear all the searches, we get the insurance, we do all the things that we're supposed to do, it doesn't stop these larger corporations or, these sort of predatory corporations from coming after our smaller clients. So we're going to fast forward, say 6 months. I'm going to come back into Michael and Mark's office. Michael.
Greta, it's great to see you. I haven't seen you in 6 months. I have this huge pile of bills for you. Let me roll out my file cabinet here. And Mark has another file cabinet full in his office. Can you just stand right there? Did you bring a dolly with you?
I didn't bring the dolly. And it's funny you mentioned those bills, all that work that we did. I'm now still getting sued. I just received a complaint from this company and they're telling me that I'm infringing on their patents, that I stole their trade dress. They're saying that my design is too much like theirs and it's would confuse consumers. And I did everything. I don't know how this could happen. I did everything you guys told me I should do.
And the thing is, and it happens all the time, you can do everything right. You can be totally right, and you can still get sued. This happens all the time. There's 3 different levels of how you can be sued. At one level, there are these claims out there that are so bad. They're going to be disposed of very early in litigation. We run into these in situations where somebody sues for a patent, but they don't own the patent, or it expired back in the Clinton administration, or we have a patent that was thrown out by another court, and now all of a sudden the inventor wants a second or third bite at the apple. So those claims die quickly. We'll take a look at yours and see if it falls in that group in just a second. The next group of claims are those where there's a legal basis. They said all the right words in the complaint, but the factual basis just isn't there. And so that's like, you're obviously not infringing, and they're just sort of pretending that you are. They're trying to see if they can get some money out of you. And I know what you're thinking. You have already had so much money drained out of you, and there's an entire dolly, which we have for a small rental fee here in the office, to pay even more bills for, but you are lucky. When they put that trade dress claim into their complaint, they invoked that $500 a year commercial general liability policy that you purchased. And all those bills that'll come in all the new file cabinets that we bought just for you in the storage room will be going to the insurance carrier instead of you. So I realize that this is one of the most stressful and taxing days of your life, but we're going to walk through how to make it a better day. The first thing that we want to do is we want to accuse the other side of wrongdoing if it's possible. If they've raised one of these claims that has no legal basis, we can point that out. If they didn't have a very strong factual basis, just the reasons for their claims aren't clear or don't exist at all, we can point that out too. Now, sometimes the court will just toss out a complaint and that'll be the end of it. But an intellectual property, when you pretend you have rights you don't have, the US Supreme Court gets really mad at you. And they get mad at you because of toilets. Toilets were the technology involved in the Sherman Act patent case of Walker Process. And what happened there is somebody sold toilets and then they filed for a patent on it later, but it was too much later and their own sales rendered their own patent unenforceable. The US Supreme Court said that when you do something like this, you violate the antitrust laws. And then not only are your bills getting paid, they have to pay your attorney's fees when this happens, but also the amount of harm that you you suffered in the marketplace because people bought this machine instead of their machine instead of yours, you get 3 times their profits back into your pocket. So what we look for in these cases isn't just how to defeat the claim, but the wizards here at O'Brien Plager, the OP, the overpowered litigation firm, are going to also look for the antitrust counterclaim, and that is the overpowered defense.
All right.
Brothers, now let's talk about what insurance do you have? Because Michael has alluded to that there may be insurance coverage. And one of the first things we have to do as practitioners to avoid possible malpractice is that we tender this to your insurance carrier. So let's look at what policies that you may have.
Well, I got the ones you told me to get.
Okay, so let's, as we're dealing with a defense here. So, if you have a policy from 1998, that is from the Insurance Services Organization, the coverage that was provided was use of another's advertising idea in your advertisement, infringing upon another's copyright, trade dress, or slogan in your advertisement. Looking at the first of the covered intellectual property claims, the courts have defined advertising idea as trademark. So since they have a trade dress claim, it potentially falls within coverage there if you have this policy. If it's, copyright, trade dress, or slogan, and you said you have a trade dress claim, we will definitely have coverage here. The other thing you have to bear in mind is, even though you have a patent claim, and patents are not covered by comprehensive general liability policies at all, because there's one covered claim, your insurance carrier has to defend the whole suit. They can't just say we're only defending part of the suit. They're going to have to also cover the non-covered claims of the patent. But if you don't have the 1998 policy and you have one of the more recent policies, we now have to be concerned as the insurance carriers have finally woken up, as they realize how expensive these lawsuits are, as you can tell by the dollies and the filing cabinets we have reserved for you. So again, as they had the original coverage claims in F and G, which were intellectual property, But then unfortunately, the carriers have gotten smart, and then it created exclusion I, which says we will not cover infringement of copyright, patent, trademark, trade secret, or other intellectual property right. However, this exclusion does not apply to infringement in your advertisement. So the key here is, do you have any advertisements of the plaintiff's product? Because if we do, is so long as we're showing that trade dress in the advertisement, we meet the exclusion and you will still have coverage. Going further, the insurance carriers more recently have changed their policy again. But the change in the policy is basically the same between the second policy form I showed you and the most current policy, which again has this F and G, the covered claims again, but as I like to say is the insurance company give it with the right hand and take it with the left hand. And so you have the exclusion once again, where they're not covering you for copyright, patent, trademark, trade secret, or other intellectual property right. But so long as it occurred in your advertisement, we will still have coverage. But as I was alluding to is, if we don't cover this, there is a potential for malpractice. California, which is where we're sitting, has acknowledged that a malpractice claim exists. But in the case that was brought by Jordache Enterprises against Robeck Plager, they were able to avoid that claim because it was after the statute of limitations. In New York says there is no cause of action for an IP practitioner for not tendering a claim. However, in the second Darby case, the court hinted at, well, that may change because as in an automobile accident case, everybody knows that there's insurance coverage. So perhaps over time, with familiarity of the subject matter, if an IP attorney does not tender it, there will be coverage because of presentations like this. So New York and California, it's a good bet that if we don't tender it, we're going to be in trouble. And we don't want any more trouble than having to litigate on your behalf.
Okay. And I'm just sitting here, and I mean, thankfully, obviously I got the insurance, and I mean, I'm hoping when I make the claim, everything's covered, but I mean, to Michael, what if I didn't have the insurance? I mean, what's the go-to? What's the most sort of cost-effective way to handle these types of, which, I mean, I find this harassing almost, because I came up with this on my own. I didn't do anything intentionally. I'm not violating anything personally. I did everything I was told to do. So I'm just wondering, what would be my go-to if I didn't have the insurance?
The best defense is a good offense. You want to get on offense as quickly as you can. In addition to the antitrust claims I mentioned earlier, there's a secret that almost nobody on the West Coast knows, except if you happen to wander into a meeting of the Beverly Hills Bar Association. This is that if somebody tried to take your listings down online, they wrote to Amazon or eBay or Etsy or wherever you're selling these, and they told the person that was hosting that website to take down Greta's awful, infringing, salacious listings, then they're interfering with a contract between you and Amazon. And they know about this contract because they have the same one for their products on Amazon. And here's the secret. Generally, you just get damages for this. And you have to prove your lost sales, except in Maryland. In Maryland, you get punitive damages as a matter of cause. And so if we march over to somebody that might be selling to somebody who lives in Maryland, we'll be able to get enough money to cover your claim and our legal fees. So that's one way. Another, we want to see if there's a way that we can cancel the claim. These aren't always the cheapest solutions, but they involve administrative proceedings. For patents, there's an administrative proceeding called, there's a series of administrative proceedings called post-grant review or inter partes review, and they can be used to cancel a patent that was previously granted. Where there's a triable issue as to whether a patent should be canceled, the USPTO cancels it 85% of the time. If we show that we're likely to win, or there's a reason we might win, we will win. The next way is that you can do a similar process in a different side of the same building by canceling the trade dress, if it's registered, with the USPTO. You can initiate a cancellation proceeding to have the trade dress registration canceled. The reason that you want to have no trade dress registration happen in your lawsuit is because if the registration goes away, then there's additional evidentiary burdens that are placed on the plaintiff. Legal strategy isn't just about making your costs low. In the epic book on legal strategy, Strategic Approaches to the Legal Environment of Business by Professor Michael O'Brien, it points out that you also want to focus on how to make the other side's expenses as high as possible. When you're canceling somebody's trademark or somebody's patent, then you're driving those costs up. And I know that you're thinking of this question. Well, if this is so good for patents and this is so good for trademarks, does it work for copyrights? And the answer is no, it doesn't. The Copyright Office doesn't have an equivalent procedure. To get a copyright canceled, you have to make a counterclaim in the current lawsuit if there was a copyright claim. And then you have to get an order, a declaratory order from the court to require that the copyright owner send a letter to the Copyright Office canceling the copyright owner's own copyright on the East Coast. On the West Coast, we just kind of pretend that it got canceled somehow as a matter of law without any filings. Not sure why we believe that, but for the last 20 years, you know, if it's green, smoke it. Like, well, we're just going with that. We're pretending that's how it works.
Got it. So the same process does not apply in copyrights. I mean, you know, that's what, and, you know, maybe Mark, you can tell me, I mean, are there such things as, I mean, I know we have patent trolls and trademark bullies, you know, we're using these terms. I mean, is there copyright trolls or copyright
In
bullies?
my experience, I've not found copyright trolls or bullies. It's more so law firms that have turned it into a cottage industry using technology to find infringements and then find the owner of the property and to represent them. So it tends to be law firm driven more so than a troll or a bully. And especially is because of the insurance coverages, you're able to have these plaintiff firms for copyright because they know that there's money at the end of the rainbow because there are these insurance policies that exist. So it becomes almost like an automobile accident. You know, the driver has insurance, there will be money at the end of the litigation, whether by settlement or by jury trial.
Oh, wow. Okay. Well, thankfully, I don't have any copyright to worry about. Okay, great. So I'm going to go ahead and I'm going to report this to my insurance. Is there anything else that I should be thinking about or considering?
You know, we have a saying here in the office. Actually, it seems like we have 40 or 50 sayings in the office, but one that's relevant here is don't perform surgery on yourself. I realize that having an insurance broker can make it seem easy to file a claim, but why don't you let us do that for you? We know all the emails, all the addresses of all the insurance companies, and we can make sure it gets to the right place. One reason we see claims denied a lot is because the insurance carrier will say, you were too slow in letting us know about your claim. Some insurance policies give a very short time frame for this. So we want to make sure that that letter gets to the right place. Let us do it for you. It's not that expensive, and it'll work out on the back end when we're able to get insurance coverage for you.
Got it. You know, it's funny because I was actually thinking when we were talking about insurance, I was wondering, and maybe Mark, maybe you can answer this for me, but okay, I'm using my insurance. This larger corporation that's suing me, I mean, this claim is completely bogus. What if they have insurance?
Well, it depends what type of insurance they have. If they have the abatement insurance, then their lawsuit is being funded by an insurance company against you. You also have to bear in mind that if we are able to get insurance coverage for you based upon the complaint as it exists now, especially if we're in federal court, we have to make a disclosure that there is insurance coverage. And the law firm representing the plaintiff could wake up and realize you're now being funded to defend against this lawsuit. They can go back and amend their complaint and remove those covered claims, leaving you without insurance, which means you're either going to have to fund this lawsuit yourself, or you're going to have to capitulate in some form of settlement.
All right. Well, it's a lot to consider here.
Well, we also have to consider that if we are filing any affirmative claims on your behalf, we have to be careful not to trigger their comprehensive general liability insurance.
What would do that?
Well, if we make a claim of defamation, trade libel, because they're out in the industry bad-mouthing you, calling you an infringer, if we were to prosecute that claim, we would now be funding possibly their prosecution of a claim against you to prove the truthfulness of the defamation claim that you've asserted against them.
Got it. Got it. So we need to be careful. Okay. All right. Well, there's a lot to consider here. Is there anything else I should know?
We're here to walk you through the process. We've described several administrative proceedings and all sorts of different claims that can be made across the fruited plain in a lawsuit. There's a lot to consider. But the first thing that we need to absolutely do is write to your insurance carrier and let them know what's going on. You don't have to use the insurance. If you want to decline the claim or cancel the claim later, that's your choice. What we want to do is we want to see as early as possible if there's a way that we can bring your costs down. Remember the game theory. Want to bring your costs down, want to bring the other guy's costs up. And filing insurance is going to do both at the same time.
Got it. Got
Once
it.
we do that, we'll write to the other side and ask for some more time to respond to the complaint in court, see if we can get the insurance company to make a decision. In California, they must make a decision in writing within 30 days, or we can rat on them to the insurance commission, at which point they're going to have a harder time declining the claim.
Got it. Got it. All right. You know, I was just thinking, if you know, I noticed that they were going after trade dress, but if we had similar names and they haven't made the allegation, but now I'm starting to get worried. And I'm wondering, you know, maybe there's some other company out there, maybe we didn't catch it in the search, or maybe they just want to come after me. What if we have a similar trademark, like a similar name or service mark, word mark rather, sorry. Is it the same process? Is there any other loopholes beyond, you know, filing a claim with the USPTO? Any other strategies that I should be thinking about? I mean, I'm really nervous now.
You always want to file for a trademark claim when you're the senior user as to everyone in the United States. That means you've been using the mark longest and before anybody else that's currently using it or has been using it in the last 3 years. Here's the trick about trademarks. There might be somebody using it who never filed a registration, that simply applied for a business through the Secretary of State's website. So we have the big fancy lawyer databases where we can check all those Secretary of State filings and see if there's somebody that might be operating a similar business to your cosmetology business that was using before these other guys, and maybe they'll let you buy those rights from them. One of our favorite backdoor strategies in trademark is to become the senior user in the United States. At that point, you're the one who's on offense. You've driven the cost for the other side up, while at the same point, bringing yours up, usually not very much.
The other option you have is to have prophylactic monitoring undertaken, where we can retain a service for you that monitors the official gazette of the U.S. Patent and Trademark Office, because anytime a trademark is filed, it is now on the register, and you will get notices if somebody filed a trademark that is similar to yours or identical to yours, or it could be done at the publication time, where you get the same notice, and at the time of publication, as a third party, you have the ability to object to and potentially defeat the registration of that mark, precluding them from having a registration.
Wow, so I sort of become the IP troll then, huh? Or
Correct. You now become the 800-pound gorilla, because you're now looking to protect your brand from any competing brands that may be confused as your brand or sound so similar to your brand that you can now carve out your territory as yours.
great. Wow. You guys have been extremely helpful. I feel very confident. I'm sorry I freaked out. Just got a little nervous. It's a complaint. It's my first complaint. So I really appreciate the advice and the counsel, and I will get those bills paid. If you don't mind lending me that dolly, I will take care of that.
So Michael, what's the deposit requirement for Greta?
Well, Greta fortunately came in here with a police escort carrying a large bag with a green $sign on it while wearing an outfit that somewhat resembled the McDonald's character, the Hamburglar. So I'm sure that the bag with the green $sign on it will be adequate for our needs. And there might be some gunfire, so we should probably get down. Are there any questions?
Yeah, so that's the remainder of our, that sort of ends the discussion for today. And I know there's the audience out there. I'm wondering if there are any questions. I did get one question earlier, and it appears Michael was able to respond, but just for anybody else who was wondering, Michael, what was the name of that book you were talking about? The one you had written regarding litigation strategies?
Strategic Approaches to the Legal Environment of Business, which is available on Amazon in both Kindle and paperback form. I would recommend reading it before you go to sleep if you find yourself anxious and having trouble falling asleep.
Thank you so much. Yeah,
One
so
of the questions from the group asked about litigation at the International Trade Commission. This deals with a slightly different kind of situation, but we do see it a lot. This would be if you were, let's say, importing something from outside the United States, and the plaintiff wanted to stop your products from coming into the United States, as opposed to federal district court litigation, which is primarily interested with products moving in commerce in the United States, as opposed to coming in. So the major differences between ITC litigation and federal court litigation are cost. It is insanely expensive to do this kind of stuff at the ITC because discovery is unlimited. Those of us with civil practice know that the number, we know the 10 deposition rule, we know the interrogatory rule, and we know all those other rules that limit discovery. Those don't exist at the ITC. Discovery is unlimited. And as a result, the discovery phase is significantly more expensive. Whereas you might be looking at, let's say, $500,000 in discovery expense here in federal court, you might be looking at $1 to $1.2 million in discovery at the ITC. I don't think I've ever seen a quote for a case that I've worked on that went to the ITC where the budget was less than $1.3, $1.4 million. So the cost is more extensive, discovery is more expensive and larger, and the remedy is different. The remedy that you're trying to get is an exclusion order. When goods come into the United States, they're inspected by customs officers, which I guess now they call themselves CBP officers, Customs Border Protection Officers, and everything gets inspected at these different areas where international packages come into the country that are called ports of entry. So at these ports of entry, these CBP officers are inspecting stuff. And if you get an exclusion order from the ITC, you give it to the Customs Service. They have a link on a special website, and then they'll make sure that stuff doesn't come in to the country. Trademark and copyright is actually much easier. You simply take your registration, you pay a fee, $450 if I'm remembering correctly, upload the paperwork onto the website, and the customs officials will check for that stuff as it comes in. Great question.
There's another question that was posted. Copyright tech plaintiff law firms, what is the best strategy to oppose them? Well, I'm assuming is that question has been posited in the absence of insurance. So if you have insurance,
copyright is almost always covered. Right. I mean, we do, Mark and I run into an overabundance of people that don't buy CGL, which is dumb. It's $500 and it covers $1 million of these claims. Everybody should get this. If somebody doesn't have it, go ahead, Mark. What do you recommend?
In the event that you don't have insurance and you confirm the registration is valid and that your client has infringed and that you have no real defenses, settle it early and for as little as you can. Mike, there's another question which is perfect for you because of the conversation we had prior to this, because you have a similar case.
I've had a couple of these. These have to do with TTAB defense. CGL will almost always cover this. Now, this is where I was saying earlier, let us work on the tender letter for you. In the tender, so one of the requirements for the CGL policy to be enforced is that somebody has to say that your trademark is hurting them. And of course, in a TTAB proceeding, somebody's going to do that. But they also have to say, for CGL purposes, there needs to be a demand for money. So what we don't see in a lot of TTAB cases is money, because TTAB doesn't give you money, doesn't give you attorney's fees, doesn't give you anything except for canceling a mark. That's all they do. So what you have to say is that this is the venue the parties chose to litigate this, and there would be damages because you are selling stuff with this mark that they say is damaging them. So there would be damages if this went to federal court. You put that little sentence in there and the CGL policy is going to pay for it. Next question is, what if you're in the middle of litigation? Will the policy be retroactive to the beginning? No, because there's an existing claim. Well, no, under the new policy that you would be considering purchasing, because there's an existing claims waiver that says that the claim had to have originated during the policy period. So the policy period has a begin date and an end date. The claim has to fit within those two lines in order for the claim to be paid.
Well, you also have to take into account the time of tender. So if the litigation is going on, let's say for 3 months, and then you realize oh, darn, I now have insurance, and you tender 3 months into the litigation, anything that was incurred as legal fees prior to tender will not be covered. So it's critical that you get that tender letter in prior to litigation and prior to you defending it and lifting and charging your client $1, because the insurance carrier is not obligated to pay for anything it was not aware of. So timing is critical. You can't, in the middle of the case or at the end of the case, say, oh yeah, I have an insurance policy. The carrier won't pick it up.
On the plaintiff side, you can sometimes do things with regarding litigation finance. If you run out of money as a plaintiff in the middle of litigation, there's a likelihood of a payout. Litigation financiers might be interested in handling a case like that for you. There's a handful that are based in California and hedge funds that are based in usually the UK. Do I advise getting insurance ASAP, if only in the middle of opposition defense? If you don't have, so I always, unless your company is going to default, always get CGL. I don't think there's ever been a situation where I've told somebody, don't get CGL, it's a waste of money. Because Mark and I, we're biased based on our experiences. And those experiences are of so many people, just like Greta in the scenario that we were walking through earlier, coming in and saying, how can you help me? And then we say, do you have insurance? And they say no. And then we're just, it makes things so hard. So do I recommend somebody get insurance even in the middle of litigation? Yes. Will it cover that proceeding? Like Mark said, it's complicated, but perhaps not. But always get it. You think that this is going to be the one bad event that happens in your life. People live a long time.
I'm not aware of a market for retro insurance. And I don't think an insurance carrier would actually cover it. It's almost buying homeowners insurance for your house after it's burned down.
See,
with that said, there's the possibility with Lloyd's of London, they will write almost any policy because Lloyd's of London is generally an excess surplus carrier. And that is what you find with the abatement policies. And what that means is an excess surplus carrier means they write the insurance, it's available, but in the event your insurance carrier becomes bankrupt, you don't have the ability to tap into the insurance guarantee fund that would then pick up in the event of the bankrupt carrier no longer covering your claim.
IPISC will write on existing claims, but the place where the co-insurance that you're going to pay is a ton. So you'd pay like 100%. I've seen the first $400,000 to $700,000 in litigation before insurance kicks in. So the deductibles on that particular line are very, very high.
What I can tell you is if the Bar Association wishes, you can likely get a presentation from someone at IPISC about all their various coverages and all the application processes. I work with IPISC. I write some of their opinions. I've also defended a case, which I ended up settling for them. But my knowledge as an insurance is I'm also defense counsel for a carrier. I'm not a policyholder counsel anymore. I did that earlier in my life. But I know how to trigger coverage for my client and then remain on the case as what was known as Kumis counsel. I don't see any other questions.
Yeah. If anybody has any other questions, we have a couple more minutes. What I'm going to go ahead and do, though, is let everybody know. Michael O'Brien Patents, I'm going to go ahead and send his website in the chat. I'm going to go ahead and send Mark's website as well. and then shamelessly send my own. In case anybody has any questions. Oh, okay, yeah, in case anybody has any questions, feel free to reach out to any one of our firms. Yeah, I mean, if you're ever looking for counsel, co-counsel, or
Or just some fun people to have lunch with on someday.
You
We're
just have
loads
to,
of fun.
you just have to go to Michigan for Michael.
yeah, and remind me, Michael, you practice in California, Michigan, and where else? Maryland?
Maryland and the District of Columbia.
Got it.
He's not the only one who's multi-coastal.
Yeah, Mark, where do you practice?
New York, New Jersey, DC, Colorado, California.
Got it. I practice in California and Maryland. All right, everyone. Well, like I said, there's the information. Feel free to reach out. Thank you so much.
Oh, can I repeat the Maryland punitive driven strategy again, please? Sure.
Oh, okay.
So the tort there is intentional interference with a contractual relationship. And what happens is you need to have the contract between you and Amazon, or between Greta and Amazon. And somebody writes a letter to Amazon saying Greta's product infringes my trademark, is the most common case that I'll see. And then what happens there is you file a claim in Maryland saying this national company, which sells goods in Maryland, took my product down and injured my contract with Amazon, because Amazon gets a piece of each thing that you sell. That intentional tort entitles you to punitive damages in Maryland. The other 12 states I've seen that have similar tort remedies don't provide punitive damages in any case that I'm aware of. Though if you all have handled any such case, I would absolutely love to see it. I will put it in the form letters that I send out.
Okay. Great. Well, I don't see any other questions. Thank you, Michael, and thank you, Mark, so much for coming and talking to everybody. I really appreciate you taking the time. You guys are extremely knowledgeable, talented attorneys. Can't thank you enough. And like I said, the information is in the chat. Feel free to reach out, everyone.
Thanks for having us.
Okay. Thank you.